Hi, good afternoon, everybody. My name is Romy Jurado. I'm an attorney here at Jurado and Associates, and I'm joined here today with my best friend and best probate attorney, Diana Collazos.
Hi, good afternoon, everyone. I hope you can enjoy the presentation very soon.
Yes. So today we're going to focus on a topic that deals with death. It's probate. We're going to try to make it as interesting as possible, but please ask us all your questions. A lot of you guys are realtors. We like to be seen as a resource to the real estate community. So feel free to put all your questions in the chat, in the Q&A, and we're going to try to answer them all so that we can help you best assist your clients. I hope you like the PowerPoint. I'm going to go ahead and start sharing my screen. But first, let me tell you guys a little bit about our office. So it's called Jurado and Associates. We're a law firm. We're in Miami. We do a lot of different areas of law. Today, we're going to talk about probate, but we also do estate planning. We do real estate closings all over the state of Florida. We do immigration all over the United States because immigration is federal law. We do trademarks all over the United States as well. We do litigation in the state of Florida. What else do we do? Estate planning, probate, immigration, litigation, and I think that's pretty much it. And if there's something that we don't do, we could always refer you to an attorney that might help you. We're fully bilingual. We speak Spanish, English, sometimes French. So I really hope we can help you and your clients grow your business. Okay, so let's start with the presentation. I'm going to go ahead and share my screen. Okay, perfect. I hope everybody can see us. And if you have any questions, please put it in the Q&A. All right, so let's start. What is probate? So probate is a court-supervised process for establishing the validity of a will. You identify, gather the assets of a deceased person. In this case, we're going to refer as the deceased person as the decedent. They also use this process to pay all of the decedent's debts and to wind up the decedent's financial affairs and to distribute the assets. So after all the debt is paid, that money that's left is used to be given to the beneficiaries. So that is basically what probate is. It's a court-supervised process. When somebody dies, all your debts get paid and the rest go through your heirs. So what assets are subject to probate? Probate administration, so we need to think of it as somebody dies, a estate is created. So like, let's say, how would you define estate in the easiest form? Okay, you guys are realtors. So let's say a house is created. So somebody dies, a house is created. Certain things are gonna go inside that house. Certain things are not gonna go inside that house, okay? So what are things that would go inside the house are called probate assets. So assets that are subject to probate. For example, anything that it's in the decedent's name at the time of death, only in the decedent's name goes in the house, right? If something is titled in the person's that died's name and also in somebody else's name, depending on how it's titled, it might go there, it might not. And that's where property falls in sometimes. A bank account name in the decedent's name will go inside that house, inside the probate state. If the bank account it's titled with the decedent's name and it says payable upon death somebody else, it no longer goes there. If the bank account is titled with somebody else's name on it, so it's not just the person that died, but it's the spouse or somebody else, it may not go inside the probate state either. It stays away from probate. So it's so important to see how things are titled. Life insurance policies, annuity contracts, or individual retirement accounts payable to the decedent's estate go inside that house. Insurance policy, annuity contracts, or individual retirement accounts payable to somebody else, not in the decedent's, not to the decedent directly, do not go into that probate state. Real estate, if it's totally titled, solely titled in the decedent's name, goes inside the probate state. If it's, for example, titled as tenants in common, right? The part that belongs to the person that died might go into the state, but the part that doesn't might not. If the real estate is titled in the name of the decedent and another person is joint tenants with rights of survivorship, this is a key word, rights of survivorship. If you have real estate title as joint tenants with rights of survivorship, that means the moment that you died, the other person got it automatically. So it does not go into your probate state and is not subject to probate. And we're gonna go into that later on. If real estate is titled in husband's and wife's name, that's called tenancy by the entireties, then the real estate automatically passes to the husband or to the wife, whoever didn't pass, and it does not go into the probate state and is not subject to probate. So just to give you a little background on that. And I see I have some questions here. Give me just a second. Would you send us a PowerPoint? Yes, I will send you guys the PowerPoint. I'm also recording this and hopefully I'll be able to send you guys the recording. That's not 100% sure because it depends how the recording comes out. This is the first time that we're doing this probate presentation. Okay, let's see. All right. So when is probate necessary, Diana? Tell us a little bit, when is probate necessary?
Well, usually when you have, like that you mentioned before, you have assets and they're titled only under the name of the deceased person. And yeah, you need to transfer title. You have an account, you have a bank account, and it doesn't have a named beneficiary. You have a life insurance policy and the beneficiary of that life insurance policy is dead as well. So it's like, it depends on the scenarios. It depends on how the property is titled. Like usually when you have a car under the decedent's name, you have it might need to go through probate. It might need, there are like some exemptions.
Okay, perfect. So probate might be necessary. So what is probate real estate? You guys are realtors, so you care about, okay, what does probate have to do with real estate? Well, anytime, whether it's an heir, seller, or buyer, the definition of probate state is probate real estate is really not gonna change. What basically happens is somebody owned real estate, that person died, and in order for the rightful heirs to have title to the real estate in order to sell it, transfer it, the heirs have to go through the formal court process called probate to officially transfer title. So if there's any real estate property whose owner died, you cannot sell it. We cannot transfer it as a title company. We can't unless there is a court order from the probate court, okay? Very simple like that. And you will face this because we have had situations where there was a listing, we were in the middle of a closing, and then the seller died. Mm-hmm. So now they cannot just sell anymore. It has to go through probate. Or a lot of times you guys may go out there and see that a house is falling apart and you come to find out that the seller of the property died. The heirs are the ones that are like, we need to sell this house, but then they need to go through the probate process. Mm-hmm. A lot of times they, don't have money, the heirs don't have money to hire an attorney in order to have the property go through probate. That happens a lot. So somebody, the aunt of somebody died, the heirs might be in Peru and Nebraska or whatever it is, the property's falling apart, but nobody wants to take out money to pay for the probate process because they're like, well, I don't know how much I'm gonna inherit, so why am I gonna pay? That's okay. We can help you with that. For you guys that are realtors, just remind me that I told you guys this and I'll remember. We can help you where if you find a property that is falling apart and you want to list it and you don't know who's going to get it, as long as you get the heirs to agree on it, we can take on that probate, start the process, and we can get paid at closing. That's something that I'm offering you guys, realtors, to help you out because a lot of times the heirs don't want to pay. So that's one thing that we can work out. Sometimes we can do that, all of it at closing. Sometimes we can do half now and half at closing, depending on how many heirs you get. Why? Because you may get half of the heirs to agree, but then the other half don't want to agree, and then we're going to face an issue. So if you have a probate property that you find, any house, we're going to be offering free consultations regarding probate. We'll talk to you. We'll see who the heirs are. We'll just, figure out what the process would be, and we can help you list it. So just remind me of that, and we'll offer that to you guys as a service in order to help you guys close the deal. Then we'll help you do the probate, do the closing, and everybody's happy and everybody gets paid. All right, let's see. So besides that, why would realtors care about probate? Well, first of all, you avoid wasting time. If you're listing a property that is subject to probate because the person that owned it died, unless you get the heirs to agree to list with you, you can be listing the property, spending all this money in marketing it, and at the end, they don't have to sell because the person that had the right to list a property would be the heirs, and they didn't sign it for you. Also, the personal representative, and we're going to explain that. Who is the personal representative and how does that work? Because if there is a probate state, unless you're dealing with the person that was appointed as personal representative by the court, then you really need to make sure that all the heirs are on board with the sale. Otherwise, you don't have a valid contract to list the property. Also, whenever you are selling real estate that is subject to probate, make sure that when you receive an offer, it clearly states that it's subject to court approval once you identified the correct seller. Otherwise, the buyer is going to say you're in default because you're not able to convey the property. And the truth is you can't, the seller can't, unless there is a court order. So things like that. If the property is titled in a trust, this is so important because we see this all the time. You want to make sure that the person that signed the listing agreement is a trustee and signing on behalf of the trust. You want to ask for the trust documents or, the trust certificate or something that tells you who the rightful person that has the right to sign on behalf of the property is and that they sign your listing agreement. If you're in the buyer side and you're buying property that is owned by a trust, same thing. You have to look at the certificate of trust. You have to look at the trust documents in order to see that the person that signed to sell this property really has the authority to sell. A beneficiary of a trust does not have the authority to sell property of the trust. Only the trustee of the trust has that authority. So you want to make sure. Now, I don't expect you to be trust experts. You guys don't have to be. We are. So send us over the listing agreement. If you're listing property subject to a trust, send us over the contract, have us do the closing. If you're selling property subject to a trust, and we'll gladly review it and tell you if we think you have the right person or if we need to go back to get the right person, okay? All right, somebody's asking, in case of investment property, husband passed away. All right, so usually property that is owned as tenancy by the entireties automatically passes to the spouse that stayed alive. How do we know if his property is subject to tenancy by the entireties? We have to read the deed. So I would need to take a look at the deed of that particular investment property so that I can tell you it was titled in both of their names as tenancy by the entireties, the wife can sell. Or it was titled in the name of an LLC. Let us look at the operating agreement. Let us see if it automatically transfers to the wife through a buy and sell provision. If it doesn't, because we've had those situations too, then we need to start a probate process. And then we need to have the court to authorize the transfer of the membership interest of the LLC to the other spouse. Okay, so it's not just real estate, because a lot of real estate is owned through LLCs or corporations. Then you cannot automatically assume that they have the right to sell. They don't. The membership interest or the stock needs to be transferred through the court, through the probate state, in order for whoever is remaining to have the authority to sell. So for you, Ms. Iris, please send us the title to the property so we can see the deed or the address. I can look up the deed. Send us the address. We can look to see who owned it, if it's a person or if it was titled in a company or if in a trust, and we can tell you exactly what to do. All right, somebody else is asking, what happens if a property is half of the deceased and half for the survivor? So what happens then?
So I believe what they are asking is in a situation when you have a tenancy in common, not a tenancy with a right of survivorship. So when you have 50% of the property owned by the deceased person, then that part has to go through probate, just that as to that 50%. So, you need to take a look at the deed to make sure.
So it depends. We always have to look, whenever dealing with property, we have to look at the deed. We have to see who is, what is it titled on, who is untitled. And then we have to see, is it a person? Is it tenancy by the entireties? Is it, rights of survivorship? Is it a life state deed? I don't know if you guys are familiar with life state deeds. We've been doing them a lot. So a life state deed, to give you an example, is I own the property while I'm alive, but as soon as I go to heaven, which I assume I go to heaven, it will transfer automatically to Diana. So in situations where there is a life state deed, it automatically transferred to the remainderment, so it doesn't have to go through probate. So again, we need to look to see how the property is titled. How long does probate take? That's a great question. I'm going to give you guys a couple of examples. So I found a house that I really like from my in-laws. I fell in love with this house. It was in front of a park for my daughters. It was perfect. And it was only I think it's 3 minutes away from my house. So awesome. I found it. I put an offer on it. I got it. And then the realtor tells me, oh, the probate process already started. Everything is going good. But then I realized that no probate process had started. And I really needed this house. So I told Diana, you need to get to it. I need to get this house. You need to start the probate process and you need to end it, get the order from the court, because I want to buy this house yesterday. I think it took you a month and a half, right?
No, much less than that.
A month?
Yeah, not even a month. It was really fast because we had everybody on board. That's
yes.
why.
So you could do it in less than a month, probate. if you have everybody on board, and there was a will in that one, right? There was a
Yeah.
will
Yeah.
that said that the son got everything, or the two sons got everything. So because there was a will, and we're gonna explain to you what a will is and all of that, and we admitted into the court, we hurry up with the process. In less than a month, the probate was done, okay?
It was homestead property too.
It was
so
homestead property
you have
too.
to notify the creditors or everything. Yeah.
And we're gonna explain all that. So that one was really fast. Now, of course, there is probate that takes longer. When does it take longer? When people start fighting. When people start fighting, it takes longer. When there are foreigners as heirs, it takes longer. So it could take as little as 3 weeks, or it could take as long as, it depends who's fighting and what are they fighting for and all of that. But whatever it is, we can help you solve it. All right, so let's see, somebody's asking, do they both have to sign the listing agreement? Whenever you're selling real estate, okay, this is important. You have to see who has title. If it's husband and wife, get the husband and wife to sign, because they can be in the middle of the divorce and one is gonna say, I never agreed to you listing my property, and the other one's gonna say, but I did. So just get both to sign. And I have those situations because we handle litigation. If it's a trust, make sure the trustee signs the listing agreement. If it's an active state that's open, an active probate, make sure the person that signs is a personal representative, and we'll explain to you who that is. If you don't know who owns the real estate, no, you know who owns the real estate, but you know the person died, you don't know who the heirs are, get as many heirs to sign. Let us look at it so we can help you decipher who should sign, and we can go from there. So the steps are, give us the address, we'll look up the title, we'll tell you who I think we need to sign. Diana will tell you too, and then you can go and get them to sign. That way you get everybody on board. You can go through the probate, fairly quickly, hopefully, and you can get your commission and be on your way looking for the next deal. So let's do that. All right, somebody's asking, wife dies without a will, husband and 5 minor children from prior marriages. Can husband sell his interest while probate is determined? No. You cannot sell anything regarding real estate unless you have a court order, unless you have 100% ownership of the property. So they're minor children, so it doesn't, so explain to that a little bit about that, because this one can get a little complicated.
Yeah, you have a lot of issues here. You're dealing with minor children. Are these minor children of the marriage?
No, from prior marriage, 5 minor children from prior marriage.
Okay, so are these his children, her children?
I guess children of the wife that died.
Okay, yeah, like in this case, was the property the homestead property?
Probably, let's assume it was.
So if it was the homestead property, what happens in this situation, and if the children are the children of the spouse who died, the husband is gonna get a life estate, and then the remainder is gonna go to the 5 minor children of the deceased spouse.
So life estate, meaning he owns it while he's alive, but he cannot sell it, and then it goes to the minor children. Very important. So no, the husband cannot sell his interest.
As a spouse, he has the right to make within 6 months of the death of the wife. He might choose to get half of the property instead of that,
So he has that choice. He can either get a life estate for everything while he's alive, and then it goes to the children, or he can choose to just get half, and then the children get the other stuff, but it has to go through probate. He cannot sell it unless the probate process is gone.
Yes.
So Orlando, you might have a little bit of an issue there that could be solved. We need to look at the title. We need to see if it was homestead property or not, and then we can tell you what we can do. So give us a call. I don't know if I put my contact information here, but for those of you that don't have it, it's 305-921-0976, 305-921-0976. And my email is very simple. It's Romy, R-O-M-Y, @juradolawfirm.com. So everybody can get our contact information. And if we're not able to answer your question because it's a little complicated, please, by all means, email us or call us so we can help you. All right. Let's see, next, let's talk about what a will is and the difference between the probate states, because you have people that die with a will, you have people that don't die, that die intestate or without a will. So go ahead.
Okay. So we are talking about testate succession. So the first thing that you need to do, it's not enough to have a will to know who the personal representative is, because you need to run it through the court, get it approved by the judge, determine the validity of that will. So we need to find out if it complies with the formal requirements for execution of the will, if it was signed in the presence of the two witnesses. Like, we really need to take a look at the will. We get a lot of wills that are basically drafted by a notary public, and they're not properly executed, and it becomes an issue because then we need to find the witnesses, et cetera, and it becomes more complicated, and everything is going to take longer, unfortunately.
So going back to will testate. So whenever you die with a will, it's called testate succession. And it's not enough that you have a document that you call a will.
Mhm.
We have to look at it to determine whether it was properly executed under Florida law. If it was, great, we can admit it to probate. If it wasn't, now you're gonna have an issue because now we're gonna have to roam around and see who executed it, or where was it, who is the notary, who are the witnesses, and it's gonna be a mess. So you're probably gonna just go through probate without a will. So we do estate planning in our office. Please reach out to us, or for your clients that need to do a will, a trust, because you wanna make sure that it's properly executed and so that it works. Otherwise, it's not gonna be admitted into probate, and you're gonna go through probate as if you didn't have a will. So a will can do many things. A will can say who gets your assets. A will can nominate who the guardians for any of your minor children are going to be. You can use a will to disinherit people. I've had clients that want to disinherit their children. I don't know why, but they do. So we have to be really specific when we disinherit especially children. You have to name them. You have to say their date of birth. If you know their social, put it there too. You want to make sure that it's so specific and clear that you meant to disinherit them, so they don't use that to fight later saying that you didn't mean to do that. So a will can do all of that, and we do that here in our office. All right, so intestate succession is when you die without a will. So we talked about what happens when you die with a will. You decide who gets what. When you die without a will, okay, in Florida, we have a process, or a system that's called per stirpes, which also means like by the branch. So basically imagine a tree with little branches. Okay, it kind of looks like that, and it goes down a list of who gets your property if you die without a will. So the first question to ask is, was the person married? Yes. Okay. Did the decedent have children? If yes, decedent's property is divided equally among the children. If a child is deceased, their descendants receive their share. Okay. Did the decedent have children? No. Then are either of the decedent's parents alive? If yes, then decedent's property is divided equally among the living parents. If the decedent didn't have children and their parents are in heaven, then did the decedents have siblings? If yes, decedent's property is divided equally among living siblings. If a sibling is deceased, their descendants receive their share. If the person had no children, no parents, no spouse, no siblings, that's when it goes to the state. All right.
Well, first it goes to the family, to the families of the parents, and then it goes to
the families of whose parents?
It says here, the decedent's property is divided half between the decedent's mother's and father's families in the following manner. If alive, to the grandfather and grandmother equally. It goes on and on until you have no descendants, basically.
Then it goes to the state.
Yeah, like
at the end. People have a will. If you don't want it to go to the state and you want it to go to a charity, have it, write it out, because otherwise eventually it's going to get to the state, and who wants to give the money to the state? All right. So was the decedent married when they died? If no, did the decedent have children? If yes, did either spouse have children outside the marriage? If yes, one half of the estate goes to spouse, remaining one half of estate split among all these decedent's children. If a child is deceased, their descendants receive their share. If no, then decedent's property goes to spouse. So it's like a little branch. Diana will go over this with you to see who gets what. You don't have to go through this exercise if people have a properly executed will. You can decide exactly who gets what, in what percentage, what they do with it. Mm-hmm. You can have a trust. A trust is even better than a will, because a trust allows you to control your assets even if you're no longer here. So you could say it goes to my child after they turn 18, or it goes to my child after they turn 30, or it never goes to my child. They just receive the benefit of it. I remember we had a situation where a spouse had written a trust where he specifically wrote that he didn't want the assets to go to the wife. He only wanted her to receive amount of money equal to support her because she had a gambling habit. And if she were to receive the stuff, she would just lose it away and not be able to support herself. And it was true, she did have a gambling habit. So you can choose to do all of that. We had clients that through their will decided to give all of it to the University of Miami to, remember, like over $500,000. That was her desire. She didn't have children. She didn't have anybody. And she wanted all of it to go to UM. So she did that. We complied with her wishes. When she went to heaven, we delivered the check to the University of Miami. Everybody's happy. Had she not done that, it would have eventually gone to the state. And she wanted to establish a scholarship. I'm very passionate about cats. You're going to realize that because you're going to see the presentation. There's a bunch of cats. We have clients, we have friends that want to leave a part of their money to their cats. Why? Because look, what I see a lot is somebody dies, they have cats. Their heirs will go and take everything from the house. They'll sell the property, they'll sell this and that, and they'll put the cats in the shelter. They won't care about the cats because they're like, okay, the person is dead, here, cats, go to the shelter. The poor cat's gonna die in the shelter, all miserable and sad. Or dog, okay, fine, or dog. In Florida, we have something called pet trust. Yes, you can have a pet trust that provides for the well-being of your pet so that when you pass, your pet is not left out in the cold. There is a trustee that will provide for the sustenance of that pet, veterinary, all of that, and your pet will be well taken care of. So you can do that as part of your estate planning. There are actually companies, nonprofits that would serve as trustee because maybe you don't trust any of your family and friends. I don't blame you. They won't know how to care for your cat, especially those that have, cats that have certain particular health issues. So there are nonprofits whose sole job, or not sole job, but one of the things that they do is to serve as trustee for your pet trust. So if you want to do a pet trust, reach out to us. I will help you with that. That's very important to me because pets, when somebody dies, they feel it and nobody cares for them, sadly. So see, I told you, I love cats. So we're going to talk about summary. So there's different types of probate, right? There is summary administration and formal administration. And we want you guys to understand that just to have an idea so that if you're faced with this, you know exactly what to do. Okay, so go ahead, Diana.
Okay, when you can do a summary administration usually when the deceased person has been dead for at least 2 years. So that it should be, it's an easier form of administration. It goes faster. It happens faster.
Like this.
But you need to be able to identify all the assets that are going to be subject to distribution and all the beneficiaries. And, and if there is a will, we do need to get it admitted into probate still. But it's a much faster process, and you can proceed with the will, proceed with the summary administration if the will allows for it. So, and it could also be done if the assets are less than $75,000. $75,000 or less, then you can proceed with the summary administration. So if the only asset is the homestead property, yes, you can proceed with the summary administration and get up and also proceed with a petition to determine the homestead status of the real property that you're trying to sell, for instance.
So summary administration, to summarize, it's available when the person that died more than 2 years ago. If the person died more than 2 years ago, you can do summary administration, which is a faster form of probate. If the assets are less than $75,000, you could also do summary administration, even if the person died last week. The homestead property does not count towards that $75,000 limit. So if there's a homestead property for $5 million, that's okay. You can still do summary administration as long as the other assets don't exceed $75,000. What assets are we talking about? Only the assets subject to probate. So if you have homestead property for $5 million, life insurance policy for $10 million, but it doesn't go through probate because it goes directly to the people, the beneficiaries, then you could still do summary administration. So don't assume that because it's a big amount of money, the assets that you see, you're gonna have to go through the longer type of administration. It might be summary administration if the assets, the probate assets do not exceed $75,000 and the homestead property is excluded. We'll file a petition to determine homestead property and we should be good. So summary administration is a faster form of probate and we can help you determine if we can do that. Then you have formal administration. So this is your regular type of probate. This is done when the assets of the person that died exceed $75,000 or the person that died died less than 2 years, you're also going to be faced this. And you want to get a personal representative appointed by the judge. Okay, so we're going to explain to you what a personal representative is. So let's say that you seek to sell real estate during the probate process. For instance, you have many beneficiaries, heir, and you would rather just deal with one individual at the time. Then you could ask the court to appoint a personal representative who basically has authority to speak on behalf of the state, even if there is 30 beneficiaries or heirs. And we're going to talk about that in a minute. Formal administration is also recommended when you have multiple creditors, when you need to provide formal notice, and also when the borrower is deceased and the bank does not want to provide information without a personal representative. We see this a lot. For those of you guys, have a list of your bank accounts, provide it to your family so that they know what you have, where you have, because a lot of times the banks will not provide information, and it's really sad. The bank will end up with your money. You don't want that. I don't want that. So make sure that you keep a list of all your stuff. All right. So a will, we discussed what a will is, kind of. We want to make sure that it's valid, right? So in Florida, for a will to be valid, it must be in writing, signed by the decedent and witnesses to comply with the execution requirements of Florida law. In a will, the decedent can name the beneficiaries who the decedent wants to receive the decedent's probate assets, and the decedent can also designate a personal representative. So what does that mean? In your will, you could say, my assets are divided amongst 40 people, but this person will serve as personal representative and speak on behalf of my state. And if this person, for some reason, is not available, cannot serve, then this other person will serve as personal representative. That's important to do because you don't want to delay the probate process, have your heirs wait for their money because they cannot all agree on something. So you want to make sure that you designate a personal representative, okay? We continue about discussing about a will. It's so important because we see a lot of times people have wills that they did in some weird website, that some, person did for some notary did for them, that some paralegal working on her own did for them. And then they bring it to us, so excited, please, let's sell this house. Here's the will, let's do it. And we look at it, we're like, this will is not valid. Okay, so you want to make sure the person has to be of sound mind, that it's so important. If the person has dementia, okay, they may not be able to do a will unless they have a lucid interval, right?
Yeah, lucid interval.
So unless during 1 second, we're able to say that during that time they signed the will, they were lucid, then we might be able to admit that into probate. Otherwise, it's very difficult. The person needs to be 18 years old or an emancipated minor, okay? So people under 18 cannot do a will unless they are an emancipated minor. It must be signed by the testator. The testator is the person doing the will at the end of the document. So if they sign and notarize at the beginning or in the middle, it's not going to be a valid will. If the testator is unable to sign the document, then some other person may subscribe the testator's name, so somebody can sign for them at the end of the document in the testator's presence and at the testator's direction. So you have to do all these things. If you run into these issues, to execute a will, we like to, videograph, we like to do all these things to make sure that it's valid in the future. And it must be witnessed by at least 2 attesting witnesses who also must sign the will in the presence of the testator and in the presence of each other. The witnesses are so important. You want to make sure that a will has a self-proving affidavit. So it's not enough that the witnesses sign the will. We want to do a self-proving affidavit as part of the will. Why? Because otherwise, when the person dies, in order to admit that will into probate, you're going to have to go chasing around for the witnesses. Mm-hmm. And God forbid the witnesses pass too. So you want to make sure that you have a will correctly executed and that you have a self-proving affidavit as part of the will. So now we don't have to go around chasing for the witnesses. Okay, let's talk about homestead property because it makes things a little easier when it comes to probate.
Okay, homestead property is basically your primary residence, is where you intend to reside and where you actually reside with your family. And, it has additional protections offered by the Florida Constitution and by Florida statutes. Okay, so even if you try to devise the property away from your minor child and your spouse, you're not going to be able to do so, even if it's titled only under your name. So if you want to do that, you cannot do it. You can only devise the homestead property to your spouse. That's the only manner if there is no minor child. Okay.
So homestead property, you cannot devise it means like to give it. You cannot give it away. If you have homestead property, it can only go to your minor children and your spouse. So you cannot disinherit them. You cannot do it, okay? Exceptions. You may devise it to the spouse if there's no minor children, okay? Or if the surviving spouse can waive homestead rights in writing with a valid prenuptial agreement. So that might be something else. It needs to be valid, it must be clear, it must be explicit, and it's almost always subject to litigation. So you want to make sure if you want to, disinherit your spouse, you want to be really careful with that, okay? If you do something and it's not valid, then the surviving spouse will take a life estate in the homestead property, and the vested remainder would be on your children. So your spouse will get the right to occupy the homestead property while she's alive, and then it will go to your children. That is if the house is not owned as tenancy by the entireties. Mm-hmm. If the house is owned as tenancy by the entireties, and meaning in both of your names, then that means when you pass, it automatically goes to your spouse. So we have to see how the property's titled so we can tell you what happens if the person passes. All right, so let's keep on answering questions. What happens if one of the owners dies without a will and it's a foreign person? The laws are according to the foreign country or with Florida laws? That's a great question because we're always dealing with foreigners and we love foreigners. So let's talk about that. So somebody died, right? Let's say they were Peruvian, that's where I'm from, and there is a property here in Miami. Who gets the property?
There is no will.
And there is no will.
Okay,
Yes.
yes. So it's always, you have to follow Florida law because the property is located in Florida. So we don't have to respect anybody else's order. The property is in Florida and there is no will. So we have to listen to Florida law. The problem with this, when you have property here is that the taxes, they have to pay additional
State taxes, yes. So for those of you dealing with foreigners, we have state tax. When you die, your assets, your probate assets are subject to state tax. And the percentage of state tax is 40%, okay? Yes, 40%. So to give you an example, let's say that the house, when the person died, it's worth $500,000. Well, foreigners have a $60-something thousand exemption. Let's say it's $60,000. So from the $500,000, there is a $60,000 exemption. So now the state tax is going to apply to $440,000. So 40% of $440,000, the state is going to have to pay as taxes before any beneficiary receives anything from the property. That's a lot of money. Mm-hmm. So foreigners should not own real estate in their own name. They could own it, and we have different structures depending on what they want to do, but they should never own real estate in their own name because then they're going to be subject to the state tax, and that's 40%. We US people have a higher exemption. I think it's like 5 million, 6 million. Yes. So we don't really think about it much, but foreigners should. So to answer your question, it doesn't matter where the person lives, whether they're not a US citizen, resident, don't even have a visa. If there's property in Florida, only the courts in Florida have jurisdiction over that property, and they have to respect Florida law. It doesn't matter what country you're from. So we're doing a lot of probates for people that have property here and they were doing probate in any other country, or they were not doing probate, and we still have to do the probate here. And that's called ancillary probate, correct?
Yes, ancillary administration happens when you have an actual open case in another country, in another state, and you're opening another, like let's say that you're domiciled in New York, like it usually happens, you're domiciled in New York or California, and then you have Florida property. So you do have to open another state here just for that Florida property.
So always, real estate in Florida, Florida probate, okay? Always remember that, and we can help you with that, and we try to do it as fast as possible. Okay, more questions. If only one person is on title, but the couple are legally married, does the spouse have to sign consent to sell?
Okay, so only one person on title. Okay, so this will be, okay, so are we talking about a deceased person?
So I guess there was only one person on title and the person died, then they have to open up a probate to see who gets the property. Yes, so then
make the determination.
We would need to see
if the property were homestead or
right, if it was homestead or what was it, and then open up a probate state in order for them to be able to sell. Okay, can property inside the property be sold during probate process? The only way property can be sold that is in a probate process is with a court order. You don't need to wait for the probate to be over in order to sell the property. A lot of times the heirs can agree together and get an order from the judge that say, sell this property because we need to get this money ASAP. Yes, and that applies to all property. It could be property like houses, it could be membership interest, it could be stocks that they own. You can sell during the probate process with a court order.
But only for a formal administration, not for a summary one.
Only for formal administration. So not for the fast probate, which should be faster, but if you're in a formal administration, you can get a court order and sell the property. Perfect. Okay, so awesome. There is Orlando property, but it's abandoned. When I search the property, it seems everyone listed for the property is deceased. Having a hard time finding who the property contact is. We'll definitely send you address to assist with this. Perfect. Yes, send us the address. Let us see what we can find out. We sometimes have certain databases that we might be able to help you so you can reach out to the right or who might be the heir and then go from there. Absolutely. I own homestead property with my parents, mother, father, and myself. Took title as joint tenants with rights of survivorship. My father has another daughter from a prior marriage. Does she have any claim in the property should father pass? No, because they're joint tenants with rights of survivorship.
That's correct.
And that does not go through the probate process. So that was smart what you guys did. Joint tenants with rights of survivorship. Automatically, if the person passes, boom, it goes to you. So you don't have to worry about that. Okay, so what is it required to properly execute a will? Okay, we discussed that earlier, but the basic requirements are the person is of sound mind, the person is 18 years old or an emancipated minor. There are 2 subscribing witnesses who sign in the presence of the testator, meaning the person doing the will, and it's signed at the end of the document, not at the beginning. You should also have a self-proving affidavit because that way you won't have to go around chasing for witnesses.
Yeah, but you need to make sure that you get, the proper notarization because.
Oh, yes,
Yeah.
please get it notarized correctly, please. Oh my God, a will was signed this date and the notary stamp expired 2 months before. That's not a properly executed will. I mean, I assume you guys know, but yes, get the right notary, check the notary stamp to make sure that there's still licensed to notarize because that's crazy. Okay. Let's see, if you have a will already, do you charge to review it to make sure it's properly executed? Send us your will, and yes, I mean, it depends. If it's for a probate consultation, we won't charge you. If you're asking for estate planning, we can probably take a look at it and let you know. So just let us know. We like to serve as a resource for realtors. We want you guys to bring us business, so we try to help you as much as we can. Can a person create a will in video form and it can be valid? No. It has to be in writing. That's one of the first requirements. So no video. You can video yourself while you do your will. Yes, absolutely. But no, it will not be valid for you to say, this is my will. I leave everything to my cats. No, it has to be in writing. All right. Let's see. Somebody's asking us to provide state tax once the apartment is sold. Again, reach out to us regarding any probate questions. And if we need to involve a CPA to talk about state tax, we will. We work with a lot of fabulous professionals in order to properly help our clients. Another question, couple divorced legally, but their condominium is in both names still. She had a will, how do we proceed? I assume you mean both are still alive. If both are still alive and the document from the divorce, right, says who gets the condominium, then all we need to do is a quitclaim deed and transfer that condominium. If one of them died, it depends. Did they die before the divorce decree was entered or after the divorce decree was entered? If it was before, then they were still married. So it depends how they were titled. If it was after and the deed was never done, it may have to go through probate. So please reach out to us, send us the address, send us the documents that you have. Let's have a call and see if we need to do a probate or what do we need to do in order to help you. We could also do title searches to make sure that everything is clean. Okay, let's see. Let's keep answering questions. We talked about homestead property. Okay, so what happens? This is a great question. What happens if homestead property is not devised as permitted? Oh, we discussed that. Then the surviving spouse and children may have rights to the homestead property, even if the owner of the property left them nothing. Yes, the rowdy husband tried to disinherit the wife. Sorry, it cannot be done. Or the rowdy wife tried to disinherit the husband and it cannot be done because it was homestead property. And this applies even if the other spouse was not on title. If it was homestead property, even if it's only in your name and you try to disinherit your spouse, you're not going to be able to, because the laws have protection for homestead property and for your children as well. So yes, we need to take a look at it and go from there. Okay, so what is a preterminated spouse? Diana, tell us a little bit about that, because that happens.
Yeah, it happens. Well, that is when, let's say that you execute your will today and then you get married a few months after. So usually you are not really thinking about your future spouse, so you don't make any provisions for that spouse in your will. So that spouse, so basically they're gonna ignore your will in that situation, because you need to provide for your spouse. And so it's usually recommended that if you're going to execute a will, do it after you get married, or
update your documents. If you get married, do your will again. You could always, update your will, because otherwise you're going to leave your spouse out in the cold. And if your intent was to leave your spouse out in the cold, then you need to do a prenuptial agreement or a postnuptial agreement, because otherwise the preterminated spouse is going to apply. So when a person makes a will and marries after the making of the will, the surviving spouse generally gets what she should have gotten had the decedent, had the person die without a will, right? Unless there is a prenuptial, postnuptial agreement addressing the issue, the will provides for the spouse. So if your will, what about if you did a will before you got married, but your will did mention your future spouse?
Yeah, that in that case, yeah, it could be it have to be clearly stated there that it's providing for your spouse, for your future spouse.
Okay, perfect. Okay, so what if a person dies without a will or legal heirs? Then pursuant to, that's what I was saying, it goes back to the state. So it's a last resort, it goes back to the state, the property sold, and the proceeds are paid to the chief financial officer of the state. Disputed funds are retained, part for the school fund, and after 10 years, the state's rights to the proceeds become absolute. So people, please do wills. All right, so what is a personal representative? We're mentioning this person. What does this person do? And can they get paid? Okay, so the person appointed by the court to oversee the administration or probate of the decedent state, who must comply with the following. They must notify all heirs or other interested parties that the will is being submitted to probate. They need to identify and take control of any state assets. They need to file the tax returns and pay the taxes. They need to pay any creditor claims. They need to manage any assets such as investment, real estate, while the will is being admitted. They must sell the assets to satisfy claims against the state, and they must file all the necessary documents and other paperwork with the court, distributing the assets to the heir and preparing and submitting a final accounting for the court. Sounds like a lot of work, right? Who wants to be a personal representative? We do, or you do, because you actually can get paid. You can get paid up to 3% of the state, correct?
Even more if you do more work. If you let's say that you're selling a house during the probate, then they're gonna give you a little bit more. You can ask for more.
Perfect. So
and it's reasonable.
So you do have to do some things, but you could get compensated for it. 3% of the state or more, depending on the work that you do if you want. So who can be a personal representative? Any person who is sui juris and is a resident of Florida at the time of death of the person whose state is to be administered is qualified to act as a personal representative. So somebody cannot be, so any person that resides here could potentially be. However, there's some exceptions. You cannot have been convicted of a felony. If you are felonious, you cannot be a personal representative.
Like the cat. No cats. Okay.
No cats. You cannot be a cat. You cannot be convicted of abuse, neglect, or exploitation of an elderly person or a disabled adult in any jurisdiction. You cannot be mentally or physically unable to perform the duties of a personal representative, and you cannot be under the years of 18. So if you qualify with all of that, if you fall under any of those, you cannot be a personal representative. So there are certain rules as to who will be the first personal representative appointed by the court. So the court wants to appoint somebody that has some familiarity with you. For example, a legally adopted child or adopted parent of the decedent may qualify. Somebody that's related by lineal consanguinity to the decedent, a spouse or a brother, sister, uncle, aunt, nephew, or niece of the decedent, or someone related by lineal consanguinity to any such persons, and the spouse of a person otherwise qualified under this section. So all those people can qualify to be a personal representative.
Yeah, if they're non-residents, yeah.
If they're non-residents, correct. So appointment of a personal representative under the statute, the order, right? If the person is testate, meaning the person died with a will, then the personal representative or his or her successor nominated by the will, you can appoint that. Or the person selected by the majority interest of the beneficiary. So all of the beneficiaries can get together and say, we want this person to be the personal representative. Or it could be one of the beneficiaries. If there are many, the court selects the more qualified. If you die without a personal representative, then it could be the surviving spouse first, or the person selected by a majority interest of the heirs, and or the heir nearest in degree. If there are many, the court selects the more qualified one. So that's what can be, oh, here's what I like, how to avoid probate. But let's see if we can answer more questions. Does your company handle short sales? Yes, we do. So reach out to us. We can help you with the short sale. We handle all types of litigation too. So we can do the foreclosure on one end and the short sale processing on the other end. Oh, somebody asked, what about my family? They live overseas. Who can be my representative? Your family, a foreigner can be a personal representative if they have some consanguinity, if they're related to you, they can be a personal representative. Or you can choose to nominate somebody here. You can choose a friend, you can choose two friends, you can choose whoever you want to be your personal representative. Let's see, we have more questions in the chat. Oh, yes, we do. Oh. Okay. How much is the approximate cost for a will? Reach out to us, send us an email to my email, and we will send you our different trust packages, will packages, and everything in between. What if you cannot find the adult children of the deceased partner? They weren't married. How do we do to find heirs? Like, is there a service? How does that work?
Yeah, like you can find like you can hire an investigator. That would be like, usually like the clients usually come here with that information. But
if not, we can put them together with an investigator, right?
Connect them.
Okay, so let's see if we have any other questions. Okay, so two partners had a house and one partner passed away. The living partner asked me to list a property. What should I do? That's a great question. So I assume the house is titled under an LLC. That's why you're saying partners. So we need to look at the LLC at the operating agreement. The operating agreement will tell us what happens with the person's interest in the case they pass away. Sometimes they have something called a buy-sell agreement, which is when the person passes away, the company has an automatic right to buy that person's interest. And sometimes they don't have that, so we need to look at the default statutes. So what we need to do is first of all, give us the address. Second, ask them for the operating agreement so that we can tell you what happens. And if we need to open up a probate for you to sell it, then we need to do that as soon as possible. We also need to know the will of the person that died, because the will of the person that died will tell us what happens to their interest in case there is no buy-sell that applies. So we need the will, we need the address of the property, and we need the operating agreement, and then we can tell you what to do. Okay, what are the best ways to build a relationship with a probate attorney? How should you approach your profession, bring value to each other? I mean, we communicate with a lot of realtors. We value your time and we like to do business together. So, I mean, I can only speak for myself. I'm not a probate attorney all the time. Diana is a probate attorney, but this is how we do it. I do mostly estate planning. Okay, so what if the same-sex couple living together for a long time and one of them died? Only one entitled, not married.
Yeah. We have this case, and it was very interesting. I was fascinated by the family of the deceased person, because here in Florida, if you are not married, you are not gonna get rights. You could be living together for 20 years, many years. You are not.
There's no common law marriage in the state of Florida.
Such thing. So
and you won't have any rights.
So you are out of luck. So we had a situation like that, and actually, it was very, very nice. So the siblings will be the heirs of the deceased person in that case, and they all decided to give up their right to the property and give that property to the partner, to the partner of the spouse. Well, not the spouse, to the partner of the deceased person.
So to answer your question, what happens if there was a same-sex couple and they were not married? Same thing if there was a boyfriend and girlfriend couple and they were not married, they don't have the rights to anything, really. Because if they're not on title, they're not married, they're really out of luck. So that's not good. So how to avoid probate? Probate is not a bad thing. It's just a process that you have to go through, but there are ways to avoid it should you choose not to. So when it comes to real estate, if it's titled by tenancy by the entireties between husband and wife, it avoids probate because it automatically goes to the other spouse. And same-sex couples can do that if they get married. Joint tenants with rights of survivorship. So you can title the property, let's say in Diana, in her name and my name with rights of survivorship. I go to heaven, she gets it. She goes to heaven, I get it. It doesn't go through our heirs. You can have a life state deed, right? So that means while I'm alive, I have the right to occupy the property. As soon as I go to heaven, she gets it. You can do a life state deed. It avoids probate. You can do a trust. We can title property in the name of a trust. It doesn't go through probate because the trust says who gets the benefit and the trustee administers the trust. So that's one way to avoid probate. You can put real estate in trust. You can put anything you want in trust. You could also do designated beneficiaries. Typically, when you designate a beneficiary for a bank account, life insurance, annuity contract, or retirement account, the money goes directly to the beneficiary without probate. For all of you that are watching this today, the first thing that you need to do is go to your bank and make sure that your accounts are payable upon death to your children. It is so sad when somebody dies and their children don't have access to any of their bank accounts because they were not paid upon death on them. And now they have to start a probate process just to get $5,000 from the bank. It's horrible, right? And there's nothing you can do because the banks will not give you the money unless the account says payable upon death to somebody else. So anyway, to conclude, we want to answer more questions if you have any. Probate is something that we can help you guys with. We have dealt with it a lot in a span of 10 years, a bunch of probates dealing with foreigners, people here all over the place. We could also help you plan. Both Diana and I are recent moms, and now it's more important than before. We think about our children because it's so good while we're here, but what happens if we're not here? So you can do estate planning, you can provide for them, you can provide for your children, you can provide for your elderly parents, because that happens too. Sometimes people died and they leave their elderly parents. You can provide for your cats, you can provide for your dogs. It's not a sad thing to plan for the future. You're not planning death, you're planning your legacy, and we can help you do that. So I hope you enjoyed our presentation today. I will be sending up a follow-up email with some information about what we do and also with information on how to reach out to us. We are offering free consultations regarding probate. So if you have any probate issue you want us to discuss, just give us a call. 305-921-0976, or you can email me, romy@juradoLawFirm.com, or through social media all over the place. You can reach out to us. We want to be your Florida probate lawyer, and we want to assist you in any way we can. So I don't think I see any more questions. Do I? I guess not, but I do see you guys are going to send us clients, so I really love it. And thank you. Thank you so much for being with us today. We really enjoy having you guys and working with all of you. And I hope you can do the same. We're fully bilingual. So for all you foreigners, we're here to help. Thank you so much. Thank you, Diana, for being here with me today. Bye-bye.